And the minute I told the hearing examiner that I was going to take the matter up with the Supreme Court, he bellowed, "You don't get to ask me questions. You're out of here."
All breaks.
That's pointing to me right now.
Correct. Well, we're on the record.
Right. I want these cameras out of my face.
Don't you touch my camera.
Yeah, I'm
Don't you touch my camera. Don't you, I want him arrested. Ah, now he's on me. Oh, no. Oh, no. Why didn't you order him out of him yesterday when he attacked me?
You're doing it again.
That's a question.
Now, you don't get to ask me questions. You get to follow my orders.
I'll take it up with the Supreme Court. I'm done talking. Thank you.
You're out of here.
The jury in this case, being duly impaneled and sworn, find the defendant not guilty. Thank you, Your Honor. Yes, thank you, Mr. Chairman. I'm going to get my BMW. Out of here.
In 20 years since I started running video of my own civil rights trials, I have not been put out of court for my conduct in probably 200 or more hearings or trials until today. And what were the factors? This case demands your full attention for several reasons. As subsequent videos will show, a competent attorney is being harassed by the legal establishment in Wisconsin because she exposes the truth about forged documents that are used to fraudulently foreclose on homeowners across the country. You may have heard the term robo-signing. Well, that's just a more palatable way of saying forgery or fraud. But robo-signing is indeed forgery, and when those documents are presented in court by way of an unlawful foreclosure, that becomes fraud upon the court. Now, in the defense of one of her clients, a court awarded a sanction of $1,000 when the attorney presented the Wells Fargo home mortgage attorney's foreclosure manual as new evidence in a RICO case. Now, we know that Judge Drain, Robert Drain, I believe it is, in New York, a bankruptcy court there, admitted that manual into evidence when it was presented by attorney Linda Torelli in terms of her attempting to show a pattern and practice of fraudulent conduct by Wells Fargo. So it's not a frivolous argument or a sanctionable argument ab initio. Now, in the other, even though she was making a valid argument regarding federal jurisdiction over Freddie Mac's claimed ownership of the debt, her client was actually ordered to pay the attorney fees of Freddie Mac's servicing agent, which had not disclosed that it was an agent for Freddie Mac. The factual allegations were made on uncontroverted evidence. The arguments in the first case were based on existing law, and in the second case were based on a good faith argument for the extension or modification of existing law. In neither case were Rule 11 sanctions granted. Notwithstanding all of that, the Office of Lawyer Regulation is now attempting to bootstrap or to leapfrog various evidentiary standards to go from having a court award a sanction attorney fees to saying that she has actually committed conduct worthy of discipline by the Wisconsin Supreme Court. Now, for you lawyers out here, note that the attorney being subjected to disciplinary proceedings when she has never been allowed to be heard or to defend on a Rule 11 violation in either case, that's crazy. It would typically be an antecedent to disciplinary action, but it isn't in this case for some reason. Now, since I showed up as media to expose this, starting last fall, mind you, okay, we came to a hearing last week in March 2017, whereupon a Wells Fargo attorney, Mark W. Rattan, disrupted the proceedings in an effort to prevent me from making a video record of the hearing, okay? Then the next day, the hearing examiner ordered me to leave the hearing when I objected to his failure to take action against the Wells Fargo attorney. This attorney had crossed an entire room to assault me. He grabbed my camera, grabbed my hand, and bellowed throughout the room and caused a great disturbance and instilled fear in me. He's bigger than me, okay? Now, both the Wells Fargo attorney and the hearing examiner acted in concert to violate my First Amendment rights to fully and to accurately record and to report on the disciplinary proceedings therein. There will be First Amendment litigation, and I've also contacted the City of Milwaukee's prosecuting attorney. More on this to follow.
Mr. Referee, we were addressing my motion for a continuance. He is now accusing me of frivolous activities, that I have not opened the floor for this argument. You have threatened me with default if I even mention these issues with respect to jurisdiction and competency. I feel that this is completely unfair of OLR to embark on this character assassination of me.
I heard your argument. I'm going to let Mr. Schwarzenbach finish his argument. I will ask some questions of you, and then I will give you a chance to respond. Your motion, as well as your argument earlier, went beyond simple adjournment today. Now, before I get there, I'm just going to warn the videographer that this hearing, I'm giving you the opportunity to be present. I'm giving you the opportunity to do what you have to do as a videographer. But I will not have you interrupt or in any way interfere with this, all right? And if I note that there's intimidation going on of anybody in this room, I will ask you to leave. So you've been warned of that. You may have a right to be here, but you don't have a right to interfere with this hearing. And I also want everybody to know that this is the only official record in this case. This court reporter is making the official record in this case. So the purpose of having a videographer here is unknown to me, but I'm letting you all know that that's my position. So when you start snapping pictures of everybody in this room, if I feel it in any way is there for the purposes of harassment, I will ask you to leave. So you're being formally warned. A videographer should set up a camera and let it run. When you start snapping pictures, you're already on questionable ground here. So you've been warned. Now,
If I may briefly, Your Honor, I have, ever since I was a trial attorney, I've been running my own videos of cases since the 90s with VHS. I have never once encountered any situation in which I've been professionally reprimanded, and I don't intend to run afoul of that today.
good. I'm glad you understand. Now, I have some questions before. Oh, first of all, I'm going to let Mr. Schwarzenbach finish his argument. Go ahead.
Thank you.
May I ask what is the purpose of this still camera here?
I'm a journalist.
I guess you do deserve an explanation. He's we'll call him the press in this case. I've indicated previously to him that stills, he's videotaping everything. The stills are not to be for purposes of harassment and are to be very, very limited. And I'm sure he's about...
Stop taking my picture, please. I did not give you permission to take my picture. Okay, he is not allowed to take my picture.
Yes, I am. This is a matter of public
I ask that
interest.
this
involving
man
an
be
attorney.
removed.
All right.
No, absolutely not. I'm within my right. We've had discussions about this already, counsel.
Okay, my previous ruling on this, I understand your position. Okay, I do. My research shows that this is a public hearing. The press is entitled to be here. I think where he crosses the line is when he sticks a camera in somebody's face and it borders on harassment. Now, he's put the camera down. How many pictures did you take of him?
But first, I don't think I've stuck the camera in anybody's face. I've remained seated. I've not put the camera in anybody's face. I'm seated in my chair. I have not advanced toward anyone. I just took 3 stills just now. I may take a 4th, as I told you earlier, in this proceeding. When there's a new witness called, I take a picture of that witness. 1 or 2, and then that's it.
All right, but now you've taken, I think you've acknowledged 3, and I think that's enough.
Well, I have 2 from him, and I don't have a good picture of this witness. That's all. I mean, I'm not...
In a limited picture or 2,
Yes.
I told you I would allow. But you need to understand that you are in very close proximity to the witness and to the attorney in this case. Possibly you'd like to stand up and get a little bit farther away, take your picture or 2, which I will permit. But there is a point in which it is very intimidating to have a camera put in somebody's face, and it is almost in his face from where you're sitting. I think that distance can't be more than 4 or 5 feet across that table. So it is very intimidating to have that happen. All right, and I told you this when we were in Madison a few months ago,
Right,
and again here. So just limit it, get it done,
Yep.
and let's move on.
With all due respect, though, I didn't want to stand up because you admonished me for standing up earlier, so I just figured I'd sit people low profile, so I can't win for losing
Right,
kind.
but, okay, you're correct in that statement, but let's get it done and move on. All right,
All
you want a picture or 2 of each witness? I told you I would find that permissible. But
Absolutely, and it's consistent with my professional practice as I've been engaged in for the past 20 years since I shot my own videos when I was a trial attorney. It's the same thing. I've never been reprimanded by any court or any tribunal for so doing, ever.
All right, well, this tribunal is concerned with the pictures taken under the circumstances I've already stated on the record in Madison, this morning, and now again.
Right.
The witness feels very uncomfortable with what, or I should say the witness's counsel feels very uncomfortable with what you're doing. And I think it's logical and that they feel intimidated
Well,
and harassed by
these
it.
are issues, to be quite honest, these are the issues of living in a free society where there's professional journalists involved. I am not harassing him in any way, shape, or form. For the record, I am going to do what I do in a minimal intrusion and move along. That's his burden.
All right, do you have another picture to take of him?
Not of him, no.
All right, you have a picture to take of the witness?
I may as it happens. I'm not going to stage it.
You want to take it now and get it over with?
I prefer not to stage it. You know, I prefer to shoot as it naturally occurs.
All right.
But I have one or two shots left of her, and then that's it.
Let's get it over with and put the camera down and let's get on with the hearing in this case. All right, he wants to take a picture of you as you're testifying. Unless somebody can give me authority to remove him from the room.
Respective of my rights, and it's a balancing point, yes it is. However, I have not exceeded that threshold, nor will I, nor have I ever. And that's his burden. I'm not taking pictures of him today, I already have pictures of him. So I'm all set.
Well, this isn't only him, it's
Right.
other people,
people.
in this room and other witnesses who may be called. So you've been warned again. And the other thing I told you yesterday, as long as we're on this subject, is that videotape camera goes off and all breaks.
That's pointing to me right now.
Correct. Well, we're on the record.
Right. I want these cameras out of my face.
Don't you touch my camera.
Yeah, I'm
Don't you touch my camera. Don't you, I want him arrested. Now he's on me. Oh, no. Oh, no. Oh,
I
no.
want cameras in my face. Okay, this is a legal proceeding. Lawyers should not.
And it has
use cameras in
been
their face.
ruled on. Counsel.
Okay.
All right, let's
Now who's offensive?
Let's all deal with this in a mature, appropriate, professional fashion.
I have been.
All right. I will make that decision. I've made my ruling. I understand your issue. That camera's been pointed at me and the witness for most of the hearing already. And
Everything counts in large amounts.
you're going to follow my orders or you're going to be ordered out of this room.
I've been following your orders, and I will continue to do so.
I'm not going to take talk back from you. If you want to take a few pictures, take them.
I wasn't
Otherwise, you're going to be ordered out of this room. You're real close.
Why didn't you order him out of me yesterday when he attacked me?
You're doing it again.
That's a question.
Now, you don't get to ask me questions. You get to follow my orders.
I'll take it up with the Supreme Court. I'm done talking. Thank you.
You're out of here. You're out of here now.
I'll take it up with the Supreme Court.
You do that.
I will.
Here's
your copy.
Oh, we were all ready, huh?
Oh, yeah, we're ready. I'm always ready.
Good.
Crap like this.
You're out of this room now.
I'm getting out now. But this man can attack me freely, and I do the slightest thing, and I can put out. Oh, I want everybody to have a copy. Here's your copy, counsel. Yep. And one for you. Yep. Yes. Anything that any reasonable party needs, I'm here to help. But I will not be attacked without consequence and assaulted without consequence. I will make the record. Thank you. That's a black tax. You know, when I had another Wells Fargo attorney call one of my clients a nigger, okay, so these Wells Fargo attorneys think they can get away with anything. I'm saying they cannot, and they will not. Thank you.
She's trying to say, okay, I'm a nigger and I got too much, I borrowed too much money and I couldn't afford it.
You don't get to ask me questions. You get to follow my orders.
I'll take it up with the Supreme Court. I'm done talking. Thank you.
You're out of here. You're out of here.